Hi everyone, and welcome to today's webinar on assisting self-represented defendants in traffic matters, presented by Candice, Hughes and Leavaiseeta. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yuggera people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. This presentation and webinar is for professional development and education purposes for Community Legal Centre staff and is not intended to provide legal advice. It is not to be used for commercial purposes without the express permission of the authors. Information is current as of the 13th of June 2019. Today, we are fortunate to have Candice, Hughes and Leavaiseeta, solicitors with YFS Legal, as our presenters. They will provide practical information on providing clients with legal advice on how to best self-represent, including basic court etiquette, preparing for court, completing and filing court documents, procedural advice, and making submissions. I'll let Candice and Vi tell you more and talk to you again at the end of the session.
Good morning. I'd like to start this morning by acknowledging the traditional owners on the land in which we're holding this presentation today, the Turrbal and Yuggera people, and I'd like to pay our respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. Today we'll start by... Oh, sorry, one moment.
Sorry,
Technical issues, my apologies. The outline today, we're just going to discuss why clients self-represent, general tips on self-representing in the Magistrates Court for summary matters, conducting the advice session, the structure of the oral submission, and work licence and special hardship applications, and pleading guilty online. The reality faced by a number of our clients who attend our CLCs for legal advice for their traffic matter is that private legal representation is not an option. Most of our services do not provide a representation service, so our clients often ask us to help them prepare so they can best represent themselves. Today we'll be covering when the clients appear in the Magistrates Court for summary matters with a plea of guilty.
Why clients self-represent? The 2014 Productivity Commission reports access to justice arrangements noted that there is not enough information available to conclusively determine the level of self-representation in Australia. However, available information does suggest that across state and territory jurisdictions, numbers of self-represented litigants have increased. The Access to Justice Arrangements report further acknowledges that there was limited evidence as to the various factors that contribute to the reason why a person self-represents. The Productivity Commission cited the following as reported reasons for self-representation: choice, because legal advice is too expensive or legal aid is unavailable; changes to legal aid funding levels and guidelines; and the requirements to self-represent in certain jurisdictions. While self-representation is often criticised as being disadvantageous to the client for reasons including an increased cost to the justice system and the risk of higher sentencing outcomes, it is often the reality for our clients. It is important to be realistic with our clients when they are deciding whether or not to self-represent. Discuss and consider with the client the time it will take to prepare to represent themselves, the ability to confidently and effectively communicate to the court, and the intimidation and pressure of the court and legal procedure. Some general tips. Use non-legal jargon. This is reiterated throughout our studies, continuing professional development, and it is because of our work that we understand the significance and impact. Use basic legal concepts and terms. Legal terms can be very confusing for the clients. Police material. It is important that the client obtains a copy of all police material before the court date, including court briefs and any attachments, such as analysis of certificate, impound notices, notice to appear. This will help identify the correct legislation. It will also assist in identifying appropriate forms and requirements. Explain the court and roles performed by those in it. Explain who is who and where everyone sits. Can even draw a rough map if necessary. This knowledge can be reassuring to some clients. Provide information about court rules, procedure, and etiquette. It is, for example, the client intends on pleading guilty. Tell the client that they will be first asked how they plead to a charge as read. The prosecutor will read out the facts, be presented copies of their criminal and traffic histories, and ask if it's correct, and asked if they would like to say something before sentence. Reiterate compliance with court directions and orders. We will discuss courtroom etiquettes in more detail shortly. Advise the client to be prepared. Being prepared with written notice is particularly helpful in highly stressful situations. This will also help the client to keep on track, present in a logical way, and stick to relevant information. Being prepared also includes encouraging the client to practice their submission. Communicating clearly in court is extremely important. Encourage the client to practice what they're going to say out loud. Honesty. Remind the client of the importance of being truthful. Magistrates have heard almost every reason to excuse, and the client is likely to get a better result if they're honest than if caught in a lie. Provide handouts of written materials and notes. There are a number of resources online that are helpful to our clients. The Queensland Law Courts and Legal Aid Queensland websites provide invaluable resources and fact sheets that can be provided to the client to reiterate and remind the client of advice given. Encourage the client to let the relevant court registry know as soon as possible if they require an interpreter. Ideally, this request would be in writing prior to the court date. If the client doesn't speak or understand English well, they can ask for an interpreter to help them in court. If the client has a hearing impairment and uses sign language, the court can also organise to have an Auslan or other sign language interpreter. An approved interpreter service will be engaged, and a family member cannot interpret. Courtroom etiquette. This is really important to go through with the client if they intend on self-representing. It can have a significant impact on the client's experience and ability to articulate their submission. Be on time or even early. Take an opportunity to observe the court. This may prove settling and assist with preparation. Also warn the client how long they may need to be at court. This may reduce frustration. Encourage the client to let the police prosecutor know that they are there. It is court protocol to stand and bow whenever a magistrate enters or leaves the court. The client should also be encouraged to bow when entering or leaving the courtroom. The client should not approach the bar table until invited by the magistrate. After approaching, the client should move to the left of the table. It's also court protocol that when speaking to a magistrate, that they are addressed as Your Honour. Further advise the client to stand when speaking to the magistrate, one person to speak at a time, reminding not to talk over or argue with the magistrate or prosecutor, even if they disagree with what is being said. The client should be guided by the magistrate's instructions. Remain polite and courteous, even if under stress. It is important not to create bad impression. Disruptive or abusive language or behaviour creates a poor impression and detracts from the value of the client's submission, including if the client disagrees with the sentence. Presentation and dress. A tidy appearance gives a good and positive impression. Dress in appropriate attire to show respect for the court. Formal dress is not required, but the client should be neat, no hat or sunglasses on the head, unless for religious observation or medical condition. If the client is particularly nervous, a support person may assist them. The client is allowed to have a friend present at court. However, they are not permitted to appear for the client. They must sit at the back of the court and remain silent. Other advice, while seems obvious, can be useful reminder to clients, including ensuring that mobile phones are turned off and no recording of any proceedings, no eating, drinking or smoking, sitting quietly and not commenting on other matters. All these things can seem obvious, but to those with no experience in the court may struggle with the experience can benefit from this information.
We'll now move on to conducting the advice session. It's good practice to create a template or a checklist. It helps us to cover all the information that's important for the client's experience. Firstly, the police material. Ask the client for all the police material that they've got, including copies of QP9s, notice to appears, complaint and summonses, criminal and traffic histories, notice of intention to allege previous convictions, an impoundment notice, anything that they've got. If the client is unable to produce these documents, only very general advice should be given, and advice should not be given on prospects. If the client doesn't have these documents, encourage the client to contact prosecution. Sometimes it's useful to give them the contact details for the prosecution's office so they can contact and request those documents themselves. Be clear with the client as to the offences that they've been charged and go through the facts and the allegations that are being made in the QP9 with the client so that they're clear on what the police are alleging against them. This is particularly important before they plead to help them with their determination of pleading guilty or not guilty. Also go through what the police need to prove to successfully prosecute them for the offences as well. If the client doesn't agree with the summary of facts, changes can be negotiated with police. Also talk to the client about standard of proof. To be found guilty of an offence, the prosecution must prove each element beyond a reasonable doubt. Talk through with the client any defences that are also available. Vehicle impoundment is often another issue that comes up with our clients. Some of the points to cover with the clients when a vehicle has been impounded include the category and type of offences for which the vehicle can be impounded, the forfeiture period, whether it's a specified period or permanent forfeiture, the first and subsequent offences and the resulting increasing penalties, also the written notice required to the driver and the owner and the costs of impoundment. Often asked about the application for earlier release of vehicles, discuss the circumstances in which an owner or a usual driver of a vehicle is able to apply for the early release of an impounded vehicle, including the approved form and the submission process. The QPS website provides good information in this area, and it's also helpful to provide the client with a copy of this information. Also discuss the options with the client, whether it be a plea of guilty, a plea of not guilty, or an adjournment, and outline the subsequent processes and what this means practically to the client. For example, if obviously a plea of guilty, depending on the number of offences or the how complicated the matter is, they could be sentenced immediately or the matter could be listed for a lengthy plea date. The matter can also be adjourned for a date so that a client could get some further legal advice or representation and so that they could make an application for a restricted licence. Relevant forms and applications. We'll talk about restricted licences and special hardship orders further, but identify all the relevant forms that are needed to be filed with the court with the client, because one of the most frequently asked questions from our clients is, am I eligible for a work licence? Vi will talk about this more in detail shortly, but if the application is not completed before the first mentioned date, advise the client to seek an adjournment so they can prepare a work licence application and to advise the court of this. Also mitigating circumstances, and we'll talk about this further on the next slide when we talk about the structure of the oral submission. Likelihood of success, as discussed before, can only really be provided once you have all the necessary police documentation and aware of all the allegations and history. Discuss the penalty, the impact or relevance of the client's current history, advise on maximum penalty, and also you can provide information on penalty range as well. Time limitations, which is vitally important, and sometimes some of us may forget those things, but necessary in our advice. It's particularly important for appeal periods and the filing of documents. Also advise the client that if they fail to attend on the court date, that a warrant may be issued. Disqualification periods. Discuss the range of the disqualification period. There may be mandatory periods of disqualification for particular offences, so you need to be clear and go through that with the client so they're not surprised on the court date. If the client is going to lose their job, if they lose their licence, they could give the court a letter from their employer clearly stating this. Whether a conviction is recorded. In appropriate cases, the impact of a recorded conviction, it is important to make submissions on not recording a conviction. Section 12 of the Penalty and Sentences Act permits a court on its own discretion to choose not to record a conviction. The Act requires the court to consider all the circumstances of the case and provides a non-exhaustive list of considerations in making its determination. Some of these factors include the nature of the offence, the client's character and age, and the impact of recording a conviction. It is also important to discuss offender levy. Sometimes this is overlooked, but it's important for the client to understand that when they get a bill for the $123, which is the current levy, so they're explained that it's not a part of the sentence, but it's a separate levy applied by the government. Referrals are really important as we provide a holistic service to our clients. So we're not just dealing with these issues. Sometimes we need to address some other issues that relate to their offending behaviour. So it may be appropriate to refer to other agencies like QTOP or drug and alcohol counselling or any other counselling that's relevant to your client. But referrals are as important as the other points too. References. Encourage the client to obtain letters of support and character references as it's assessing sentencing. And I also advise the client on an appeal period that the client has 28 days from the date of decision on which to appeal a decision, or with the district court's permission to appeal outside this time if there's a sufficient reason. And also go through the points that Vi raised earlier about court etiquette. It just helps with their experience in court. So go through things like Vi mentioned about when they enter the courtroom, when they're standing, when they're speaking, what to expect, who to expect in there. It just relieves some of the client's anxieties and helps with their experience and their presentation to the court. We just move to the structure of the oral submission. It's really helpful for the clients to have a clear guide on what they're going to say before they go to court. They don't want to say too much. That'll get themselves into more trouble. But encourage the client to organise their notes prior to court and let them know that it's actually okay to read from their notes, and just write down their points in a structured and logical manner. When starting their oral submissions, the client should start with the antecedents. Get them to state their age, their family circumstances, where they live, who they live with, if they're working or they're studying, their current financial arrangements, if they're caring for somebody, if they drive their kids to school, and any other medical information that is relevant. Then get them to explain their offending. The client should provide a court a mitigating explanation for their offending behaviour if there is one and if it's relevant. To provide information on mitigating factors that influence the way the client acted. For example, a client knew at the time of the offence she was unlicensed and unregistered, but to leave an unsafe situation in the family home, she put her kids in the car and drove the vehicle to remove herself and the kids safely from the situation. So tell the court that. Those are mitigating circumstances that the court will take into account. Review the sentencing guidelines prescribed in Section 9 of the Penalty and Sentences Act and assist the client in applying these to their matter. For example, any damages that have been caused, the client's age and character, the client's remorse in cooperation with police and their history. Remind the client that they should not try and make excuses for their behaviour and not to say anything that's untrue. Then get the client to move into their attitude to their offending. Encourage your client to talk about the impact the decision which has led to them being before the court has impacted on their life, their relationships, their work, and if they're remorseful, embarrassed or ashamed. If the client is in danger of losing their licence for a period, talk about the impact this will have on themselves and their family. Also ask the client to speak about their supports and future goals. So if the client's receiving support from a counsellor or an agency, mention this. It helps to paint a picture about what the client is doing or has done to address their offending behaviour. For example, any drug and alcohol counselling. And if the client is able to, get them to ask their service or their counsellor to provide written confirmation in this. It assists in support letters with court. So encourage the client to gather these support letters and character references. It might be helpful, and it might also be helpful to give your client a guide on how these can be drafted. This can be found online, or different organisations have their own internal copy that can be provided to their clients. This also assists in appropriate things being provided, information being provided to the court. It also gives examples of the good things that they've done. So if they volunteer at a kids' soccer club or at the school's canteen, some of these letters can also be beneficial. And finally, it may be relevant for the client to talk about their ability to pay a fine, for example, as a penalty, or they may be asked to make submissions or talk to the magistrate about a particular penalty that the court is considering and imposing. If the court is considering a criminal conviction, it may be relevant to discuss how the criminal conviction may affect the client's future. Encourage the client to tell the court about the impact this will have on the client's ability to work now or in the future, or effect on any travel plans. And evidence should be provided if this is going to impact.
Work licence and special hardship applications. Work licence, which is officially called a restricted licence, enables a driver to drive when their driver licence has been cancelled, suspended or disqualified because of a drink driving or similar offence. Work licence, and what's important that the client should know is that work licences are not automatically issued because the driver needs their licence for work. If granted by the magistrate, usually puts conditions on the work licence like times or travel and for work purposes. Also, your client needs to be eligible in order to apply for a work licence. Your client needs to plead guilty to one of the following charges: drink driving, in charge of a vehicle while over the limit, driving with a relevant drug, for example, cannabis, ecstasy, or ice, in the saliva or blood, failing to provide breath or saliva sample, but only at the roadside, not at the police station. Has held a current Queensland open driver licence, but their blood alcohol level has to be less than 0.15%. And the client was not driving on a work licence at the time the offence was committed. And that the client hasn't been convicted anywhere of drink driving or similar offence in the last 5 years. Also, that their licence was not suspended, cancelled or disqualified in the last 5 years. This includes their licence being suspended due to failing to pay outstanding fines. It is also important for the client to know that the alcohol content of 0.15% or more, the law will consider that as under the influence, and therefore cannot apply for a work licence because they'll be charged with a more serious offence. It's important to go through the strict eligibility requirements with the client in terms of both relevant offences and licence, alcohol limits and history. In addition to these requirements, it is vitally important that the application is made to the court at the time the person is convicted and before the court orders the licence to be disqualified for licence disqualification. What you need to show the court. If the client meets the eligibility requirements, the client may then apply to the court for a work licence and show two things: that the applicant is a fit and proper person. If the applicant is not granted a work licence, this would cause the applicant or family extreme hardship because the applicant will lose their job. It is important for the client to mention this to the magistrate on their first appearance at court. The documents required. Section 87, application form. These forms can be picked up at any magistrate court, or you can provide a client with a copy. An affidavit also needs to be completed and attached to the application. They will also need to get their employer to sign an affidavit as well, and their criminal history as well as traffic history to be attached with their application. Special hardship applications, again, go through the eligibility requirements with the client, including the paperwork that is required, the application, affidavit, potentially a statutory declaration, and traffic and criminal history. Inform the client that they may need to answer questions about their application and affidavit the court may have. Discuss filing of the documents, including filing fees, and also that the client needs to be made aware that there needs to be 3 copies of all documents. File with the court within 21 days of the licence suspension. A copy of the application and supporting documents must be given to the Department of Transport and Main Roads at least 7 days before the hearing date. It is important to note that the driver licence suspension will be temporarily lifted from the moment of the filing with the Department of Main Roads until the day before the matter is heard in court. For both applications, it is important to discuss the consequences of driving outside the special hardship or conditions, specifically disqualification. The Legal Aid website provides some excellent resources that can be provided to the client as examples and step-by-step guides. Pleading guilty online is possible if it is a minor offence, including speeding or driving uninsured, unregistered. However, it must be noted that the plea will not be accepted if a conviction would result in driver's licence disqualification. The application must also be submitted online at least 2 business days before the court date. It is also good practice to follow up with the court that the application was received prior to the court date.
Alright, so now we've got time for some questions. If anybody has a question, if they'd like to type it into the little question box, and I'll read it out for Candice and Vi to answer.
No question.
Yeah. While I'm giving you some time to type in any questions, I'd like to thank all of you for attending this webinar and also give a big thank you to Candice and Vi for such a thorough and interesting presentation.
Thank you.
So I'll just give you a few more minutes if you had any questions. I know their presentation definitely covered a lot, so they might have covered everything that you were wondering about. All right, well, if you do have anything that you'd like me to pass on, just send through an email, amandaw@communitylegalqueensland.org.au, and I can forward that through. Thank you everyone for attending, and the recording and the PowerPoint will be available online.